California Real Estate Principles Review Test Audio Unit 5. A conditional offer is an agreement between two parties that an offer will be made if a specific condition is met. Conditional offers are used in real estate transactions whereby a buyer's offer on a home is contingent on something getting done for the purchase to go through. What is a condition in an offer? A condition is a clause the buyer needs to waive or fulfill by an agreed time in order for the sale to be finalized, while a term is used to clarify what the buyer expects to be done or included with the property. What is a legal term for a condition in a contract? A condition precedent is a legal term describing a condition or event that must come to pass before a specific contract is considered in effect or any obligations are expected of either party. What are the three kinds of condition? The types of conditions in a contract can vary, but common ones include conditions precedent, conditions concurrent, conditions subsequent. What are the different types of conditions in real estate? The common conditions precedent are buyer financing, property inspection, state of property title, fire, property insurance, and property disclosure. In addition, there are several other due diligence investigations that could be completed as a purchaser investigates the property they intend to purchase. What is the purpose of a condition in a contract? A term of a contract which is of such vital importance that it goes to the root of the transaction. Essentially, it is a major term of the contract. Breach of a condition gives rise to the claimant's right to terminate the contract, treat the contract as discharged, and claim damages for any loss. What is a clause versus condition? A clause can be defined as an independent concept within the written contract. A clause may have any number of subclauses. A condition is a clause in a contract or agreement which has for an object to suspend or to alter the obligation principles. What are the four conditions of a contract? The basic elements required for the agreement to be a legally enforceable contract are mutual assent, expressed by a valid offer and acceptance, adequate consideration, capacity, and legality. What are the five conditions of a contract? The five requirements for creating a valid contract are an offer, acceptance, consideration, competency, and legal intent. The grantee is the buyer, recipient, new owner, or a lien holder. What is the definition grantee versus grantor? In real estate, a grantee is the recipient of the property, and the grantor is a person that transfers ownership rights of a property to another person. Which party is the grantee? The party receiving the property is the grantee. Is grantor the same as owner? In real estate, the grantor is the current property owner. Typically, this type of language is used when transferring ownership or selling a home. In these situations, the grantor is the one selling or giving the property to another party. Grantors can be property owners, banks, county sheriffs, etc. Is grantee the same as beneficiary? As the name suggests, a grantor grants assets or property to a grantee, beneficiary, the person or entity receiving the assets. Is grantee giver or receiver? A grantor is the giver of property, whereas the grantee is the receiver of property. What does first grantee mean? The grantee is the party who receives the transfer of the property after, in the case of sale, a closing occurs. In other words, the grantee is the buyer. A restrictive covenant is an agreement you make with an HO that limits the way you can use a property. Restrictive covenants are general rules that members of your HO vote on that all homeowners living in the area must follow. What is a covenant and restriction? Covenants, conditions, and restrictions, commonly called CCRs, are a set of rules governing the use of a certain piece of real estate in a given community. For example, a CCR can regulate the fences around a house, the type of garbage cans allowed, and whether parties can open businesses in the community. What is an example of restrictive covenants? When a party enters into a restrictive covenant, he or she agrees to refrain from doing something or from using a property in a certain way that is restricted by the contract. For example, when purchasing real estate, the buyer may agree to use the property for the designated purpose only and not for other purposes. What does covenant mean in real estate? A property covenant is an agreement between two or more parties regarding certain use of a piece of real property. The covenant will either benefit or burden the landowner. A covenant that burdens the landowner is also called a restrictive covenant. What is a deed of covenant restriction on title? A restrictive covenant can be defined as a private agreement between landowners where one party will restrict the use of its land in some way for the benefit of another's land. Restrictive covenants, once agreed between the parties, are placed in the title deeds to the property as previously stated. An encumbrance is a claim against an asset by an entity that is not the owner. Common types of encumbrances against real property include liens, easements, leases, mortgages, or restrictive covenants. Encumbrances impact the transferability and/or use of subjected properties. What is an example of an encumbrance on a property? Common types of encumbrances include liens, deed restrictions, easements, and encroachments. Certain types of encumbrances, including liens and easements, give another party a claim to or right to use your property. What is encumbrance? Give example. An encumbrance is a claim against a property by a party that is not the owner. An encumbrance can impact the transferability of the property and restrict its free use until the encumbrance is lifted. The most common types of encumbrance apply to real estate. These include mortgages, easements, and property tax liens. What is an encumbrance on property ownership? Also known as encumbrance. In a real estate context, any burden, interest, right, or claim that adversely affects a real property's use and value but does not necessarily prohibit the ability to transfer title. What is free alienation of property? Alienation refers to the process of a property owner voluntarily giving or selling the title of their property to another party. When property is considered alienable, that means the property is able to be sold or transferred to another party without restriction. What is an example of alienation in real estate? For example, your lender provides you a loan in exchange for the title, which the lender then uses as collateral while you repay the loan. Similarly, your lender uses the alienation clause to ensure that they make back the money you borrowed even when you sell or transfer ownership of your home. What is the difference between alienation and transfer? Alienation simply means transfer. Basically, this is a fancy way of saying you sold your house. This is accomplished by the grantor, seller, giving a deed to the grantee, buyer. Thus, the title is transferred to the buyer. Homestead exemption, a partial equity protection in a home. The homestead exemption was designed to assure that a judgment debtor has a place to live even if they owe money to creditors by protecting a portion of the equity in a home in California from being used to pay a judgment lien on the property. A homestead exemption protects the value of a home from property taxes and creditors following the death of a homeowner spouse. Homestead exemptions come in two types. One protects the home from being seized by creditors, the other reduces your state property taxes. Homestead tax exemptions shelter a certain dollar amount or percentage of home value from property taxes. A cloud on title is any document, claim, unreleased lien, or encumbrance that might invalidate or impair a title to real property or make the title doubtful. What is a cloud on the title? A cloud on title is a claim or encumbrance that affects the ownership of a property and can potentially discourage future parties from purchasing it. These claims or encumbrances can arise from easements or mortgages on the land, or they can arise from a defect on a deed or a lien that may yield title to a third party. What is the most common cloud on a title? A cloud on title can take many forms, but the two most common are an encumbrance on title and a defective title. Encumbrance on title: someone other than the owner claims a legal interest in the property. Which of the following would cause a cloud on title? You might see a cloud on title because of a mortgage lien, a tax lien, foreclosure proceedings at the property. Which of the following is an example of a clouded title? Examples of clouds on title include a property's address being misspelled in a deed conveying title, a mortgage lien whose repayment hasn't been officially recorded, a deed which has been signed but hasn't been properly recorded, an easement that has not been properly recorded, unpaid property taxes. What may happen to a transaction if cloud on the title is discovered? Usually, the seller must take action to remove any clouds on the title. A suit to quiet title may be filed by a buyer in an attempt to remove a cloud on the title. Often, especially when a lender is involved, the discovery of a cloud halts the transaction. A mechanic's lien is a hold against your property, filed by an unpaid contractor, subcontractor, laborer, or material supplier, and is recorded with the county recorder's office. If unpaid, it allows a foreclosure action, forcing the sale of the property in lieu of compensation. Which of the following would be entitled to a mechanic's lien? How to determine if you can file a mechanic's lien. The general rule is that anyone who provides labor, materials, or professional services for the permanent improvement of a structure is entitled to lien rights. What is the purpose of a 20-day preliminary notice for private work? Their role is to inform a property owner about a claimant's right to file a mechanic's lien against the property in case there is no payment. A preliminary notice in California is meant to benefit the general contractor, property owner, and top project members. A notice of cessation is used when work has temporarily halted for more than 30 days. How many days of inactivity must pass before a notice of cessation may be recorded? 30. A notice of cessation is used when work has temporarily halted for more than 30 days. What is a California notice of completion? To review, a notice of completion in California is a document that the owner may file at the end of the project. Its main function is to set the date of completion of the construction project in stone. Who files the notice of completion in California? Who needs to file a notice of completion in California? The project owner or general contractor may file a notice of completion in California. Generally, the owner is responsible for filing this document and getting it recorded, as it must be signed by the property owner. The recording of a notice of completion is one of several methods used to trigger the time period for the recording of mechanic's liens and service of stop payment notices. How do I enforce a mechanic's lien in California? To enforce the lien, the contractor must file a lawsuit within 90 days from the date of recording the lien. If this deadline is passed, the contractor may not be able to enforce the lien and may be required to remove the lien. The preliminary notice. If you receive a preliminary notice, don't panic. The preliminary notice isn't a lien, it is a notice that a subcontractor or supplier has provided or will be providing goods and or services to improve your property and could file a lien claim if he or she is not paid. A preliminary notice is a construction notice sent by a contractor, supplier, or equipment lessor to inform the property owner of their work on the project. What is the meaning of preliminary notice? What is preliminary notice? Preliminary notice is a notification to the owner or general contractor of a construction project to notify them that a contractor, subcontractor, materials provider, or other party is reserving their right to file a mechanic's lien in the event of non-payment. What is required for a preliminary notice in California? Preliminary notices must be filed 20 days from first furnishing labor or materials. The preliminary notice requires delivering a notice to property owner's statement in person or by certified, registered, or express mail, or overnight delivery to the property owner, with a receipt of the mailing as proof. What is the purpose of a 20-day preliminary notice for private work? Their role is to inform a property owner about a claimant's right to file a mechanic's lien against the property in case there is no payment. A preliminary notice in California is meant to benefit the general contractor, property owner, and top project members. What is a notice of non-responsibility? A notice of non-responsibility is a legal document used by property owners in the U.S. to protect themselves from liability for non-payment for services done to improve that property. What is a notice of non-responsibility, California? A notice of non-responsibility is written notice that the person signing the notice, or the entity for whom the person is signing, will not be responsible for any claims arising from the improvement. What does judgment lien mean in California? A judgment lien is a lien that attaches to a property of a party who owes money to another party as a result of a court judgment. What is the difference between lien and judgment? The easy definition is that a judgment is an official decision rendered by the court with regard to a civil matter. A judgment lien, sometimes referred to as an abstract of judgment, is an involuntary lien that is filed to give constructive notice and is to attach to the judgment debtor's property and/or assets. What type of lien arises as a result of a judgment? A judicial lien is created when a court grants a creditor an interest in the debtor's property, after a court judgment. What is the meaning of writ of execution? Description. A writ of execution is a process issued by the court directing the U.S. Marshal to enforce and satisfy a judgment for payment of money. What is an example of writ of execution? A writ of execution can also be used to evict a tenant who will not leave on their own and who will not pay rent. In the event of a tenant's eviction, the issuance of a writ of execution allows the tenant and their belongings to be removed from the residence. What is a writ of execution on real property in California? The writ authorizes the sheriff to levy on specific real property and initiates the process for the sheriff to sell the property at auction. The proceeds would be credited toward the satisfaction of the money judgment. What is writ of attachment? Attachment is defined as a remedy where a plaintiff can seize defendant's property before judgment to secure any recovery the plaintiff may recover in a pending lawsuit. It can only be used where there is a lawsuit on file claiming that money is owed. What is an example of a writ of attachment? A writ of attachment is commonly used by a plaintiff to secure a contingent lien on a defendant's property in the event that the plaintiff obtains a judgment against the defendant. What does writ mean in legal terms? A writ is an order issued by a legal authority with administrative or judicial powers, typically a court. What is a writ of attachment in California? States the court's order to the sheriff to attach, take and hold, property belonging to the defendant in a civil case. In California, an easement is defined as a right granted to an entity to use a piece of property belonging to a separate individual or entity for a specific purpose. The most common types of easements in real estate are those that grant road or utility access. What is an easement in simple terms? An easement is the grant of a non-possessory property interest that provides the easement holder permission to use another person's land. What is an example of an easement? A common example of an easement is when one person is given the right to cross or access a road across another person's property. Other common examples of easements are phone, gas, and power lines. What is another name for easement in real estate? The legal right to use another person's property, also known as a right-of-way, for a certain purpose refers to an easement. Servient tenement is a parcel of land that is subject to an easement and benefits another parcel of land. What is a dominant tenement and a servient tenement? The land to which an easement is attached is called the dominant tenement. The land upon which a burden or servitude is held is called the servient tenement. What is an example of dominant tenement? Dominant tenement, also called dominant estate, refers to property that uses an easement over another property. For example, if Lot A had an easement over Lot B to access water lines underground, Lot A would be the dominant tenement and Lot B would be the servient tenement. The easement in gross is a personal right that allows a person or entity, who does not possess a property, to use it. What is an easement in gross mean? An easement in gross is basically selling rights to the land to another person, but without giving them legal ownership. An easement appurtenant, on the other hand, is a permanent encumbrance, legal right, to the property. What is an example of an easement in gross versus appurtenant? With an easement appurtenant, the dominant estate A, your neighbor, for example A, holds the right to the land. With an easement in gross, the users of the easement aren't estates, but they're people like those who work with utility companies or services. What is another term for an easement in gross? An easement in gross, also known as a personal easement, attaches the right of use to a single individual or entity rather than to the property itself. What is the most common form of easement in gross? A common example of an easement in gross is a public utility line easement. A utility company with an easement in gross has an interest or right to the land where the utility lines, poles, pipes, etc. An easement by necessity is an easement that occurs when the use of the land is absolutely necessary. Unlike implied easements, this type of easement doesn't require pre-existing use of the land as an easement. If someone's property is landlocked, they may need to use a portion of another property to get to the street. What does easement by necessity mean? An easement by necessity is defined as an easement created by operation of law because the easement is indispensable to the reasonable use of nearby property, such as an easement connecting a parcel of land to a road, Black's Law Dictionary. What is an example of easement by necessity? Giving a landowner right-of-way over an adjoining parcel of land in order to access a public road is the most common example of an easement by necessity. What is easement by implication? Easements by implication exist when there is not a recorded easement, but the circumstances show an easement was intended. They commonly arise when someone divides a parcel of property and conveys part of the parcel to somebody else. Which of the following is an example of an implied easement? For example, a large piece of land on a lake may be divided into two lots with only one having access to the water. An implied easement may exist to allow the owners of the inner lot to get to the lake. What is an example of an encroachment in real estate? Here are some encroachment examples to watch out for. Your neighbor builds a fence, and it extends onto your land. A structural addition to your neighbor's home extends beyond the legal property boundaries. An overgrown garden or hedge crosses onto your land. What is the difference between encroachment and easement? People often confuse encroachment as sometimes confused with easement. Both involve a property owner making extensions over their neighbor's property. While encroachments are the unauthorized use of the neighbor's property, easements are agreed upon by both parties. Termination of easements. An express agreement occurs when the easement owner and easement holder agree to terminate the easement. Abandonment of an easement occurs when the holder of the easement takes action to stop using the easement permanently. Which of the following is generally considered a method of terminating an easement? Easements will continue indefinitely unless terminated by an express agreement, abandonment, merger, or a lack of necessity. Easements may generally be terminated when the easement holder and the easement owner agree in writing to end the easement. Which of the following can't terminate an easement? There are 8 ways to terminate an easement: abandonment, merger, end of necessity, demolition, recording act, condemnation, adverse possession, and release. Is a long period of non-use sufficient to terminate an easement? Yes, a long period of non-use is sufficient to terminate an easement if it is accompanied by other evidence of intent to abandon the easement. For example, the easement holder erects a permanent structure blocking off the easement. What is an example of easement termination by estoppel? For example, if you have an easement to use a trail on your neighbor's property, you may lose the easement if the owner of the land blocks the trail with a fence for the statutorily required period of time. The equitable doctrine of estoppel may also lead to the extinguishment of an easement. What does estoppel mean in property? Estoppel by deed is a doctrine that precludes individuals from arguing in court a position counter to what that person stated in a previous deed. The doctrine arises most frequently where someone deeded property they did not own, and later, they are involved in a dispute involving the property. What does estoppel mean in simple terms? What is estoppel? The term estoppel refers to a legal principle that prevents someone from arguing something or asserting a right that contradicts what they previously said or agreed to by law. Put simply, estoppel prevents one person from contradicting an action or statement from the past. Homestead exemption in California: head of household receives a $100,000 equity exemption. Seniors over 65, physically disabled individuals and those who earn less than $15,000 per year receive a $175,000 exemption. What defines a family unit? The basic family unit consists of one or more adults and children, if any, related by blood, marriage, or adoption and residing in the same household. There may be more than one family unit in a household. What is the homestead exemption amount for a family unit in California? Homestead exemption in California. In California, everyone who owns a home and lives in it is allowed to claim a homestead exemption. As SF Gate reports, single homeowners receive a $75,000 equity exemption. A head of household receives a $100,000 equity exemption. This is the end of Unit 5.